All right, I think we'll get started on I believe our last panel of the day, and we'll take the same approach as before. Each presenter will present for 10 minutes, then there will be a response for 10 minutes. We'll go through all three papers and then open up the floor to questions and comments for 30 minutes. So our first presenter is Lyria Bennett Moses on legal education in an era of convergence.
Okay, thank you. So when Murray asked me to do this, I sort of had a bunch of things that this conference had inspired in my mind, and this was one of them. So that was sort of the basis for it. It comes about mainly because of three thoughts that I'd been having. One is that a lot of people in one discipline that try to do things that involve another do it terribly badly. And the classic example of that was Karen Jung's speech, and she gave some really scary examples a number of years ago at a conference, of lawyers trying, senior experienced legal academics trying to describe artificial intelligence and completely stuffing it up, so that whatever they were commenting on legally wasn't actually the thing that computer scientists meant by that term. The second one is that we box ourselves a lot. Particularly in academia. So, people are, a lawyer, a legal academic, or they're a computer science academic, and we put ourselves in these boxes. And is that inevitable? Like, are those the right boxes? They're the ones that have often come about through a particular, history, but are they the right boxes? And the third is that we don't get the same boxes in the, for lack of a better word, non-academic world. So in most roles that people take on in organisations or government or world policy or wherever they are, aren't, this is for someone who has, this particular background. I mean, lawyers obviously have a law degree, that's a bit different, but for a lot of roles, it's actually bringing various things together from where we cut things up as universities. So then the question is, okay, if we're looking at something like computational law, what might we do differently, right? What might we do to, if you like, encourage students to think outside the four corners of a particular discipline? And I should say, I started with the law degree. One could start from a computer science degree and look in the opposite direction. And when I first looked at this, which was a number of years ago, I kind of said, well, there's three things we need to think about for a law degree, right? If we're thinking about the sort of technologies that future lawyers will need to understand. There's the stuff that everyone needs to know. So to a certain extent, the idea of automation, code-driven and data-driven, everyone needed to understand, because we were already seeing those in government systems that could be challenged in court. So there was a sense in which if you're going to do things like administrative law, if you're going to look at things like criminal justice, you couldn't not have any understanding of what those kinds of systems do. So that's a kind of base knowledge that is almost core for being a lawyer going forward. Then you have the sort of electives, right, that people can choose particular things. Maybe they do a course, one of the sort of legal tech courses, or maybe they do a fintech course, or they do, whatever. They look at a particular kind of technology and they learn about the law relevant to that at that sort of elective level. And the third category was the sort of dual degrees, which is a thing in Australia where, what combinations were students doing? And in Australia at the time when I did that, there were sort of almost 200 commerce law students and 2 computing science law students per year in my university. So do we change those combinations and try to encourage more students into different degrees? Marie Hildebrand wrote a paper more recently, which was more of a learning outcomes approach, right? Which I really liked, which is what are the learning outcomes we actually want law students to have in relation to technology? And they were very well written. I'm like, yes, I wish I'd said that when I first looked at this. And I'm not going to try to change it for this piece. So you can read Murray's paper for that. And the third kind of approach was a colleague of mine, Michael Legg, who at our university a while back sort of wrote a sort of like, what do we need to add? And it included things that I thought were quite simplistic, like, we should have like a first year computing science course that law students can do. And I'm like, I don't know if they'll pick up the relevance of that just by doing, computer science 101. But there are a lot of, questions about, what one can bring into a law degree. So that's sort of approach number one. Approach number two is, how do we actually get students to do what we do? And I'd love to hear of other experiences. They do a degree program and they're being trained just in that, and they're only in classrooms with people from that degree program. And even if they do dual degrees, which almost everyone in Australia does in law, they're in two separate sets of classrooms and the conversations actually don't meet. So we created a course that I did with computer science and engineering. The law course is called Regulation for Cybersecurity. The engineering course is called Security Engineering and Cybersecurity. And we actually do that. So there are separate components. I teach, privacy law and critical infrastructure regulation and, the regulatory landscape more broadly and cybercrime and all of that kind of stuff. The engineering students do, bits of security calculations, types of encryption, that kind of stuff. They come together for basic security concepts, so how to think about risk, how to think about assets, how to do, red team thinking, all of that kind of stuff. And then in tutorials, which is the best part, is they're solving problems together. So the computing students, the law students share a tutorial, and they're all sort of policy type problem solving, like what do you do in this situation? And they have to do what we do in this conference to solve the problem, right? They have to actually integrate their different knowledges through, conversations and so forth. Now that's not perfect. I mentioned some issues with it in the paper. We're still working on it. It's also very administratively complex. I think everyone in university admin hates me. It's very hard to schedule, all of that, bureaucracy. But, there's that kind of an idea. And I know people who are doing that in other spaces too, including in other universities in more of that computational law space, right, where you create common classrooms for building things. Then the third option, which is sort of the most kind of crazy, but nevertheless, was where my brain was going when I started thinking about this, is we change the borders, right? So we create different kinds of programs for students to do. Now, this has already been done before. So you can think about something like criminology. There wasn't criminology, right? There was social science and there was psychology and there was, there was law, there were various different things. And they said, no, this is an area, this is a problem space that is important. And we're going to create a degree program in criminology to teach people all of those different elements relevant to that problem space. I talk about a little bit like what's happened in medical training in my university, where they've moved from making the students do, biology and biochemistry and anatomy and to a problem-based approach to medicine. So it's like, and then they look up those things. They learn the anatomy and the physiology and the whatever as they go through from a problem lens. So it's still medicine is still a discipline, but they're learning it, the subdisciplines, if you like, the different strands of knowledge they bring together in the way they structure the degree. Now, could one do something like this? I actually think of the two different areas I kind of think about the most nowadays. Cybersecurity is perhaps an easier example, right, of something where this could really work. It's a big enough area in industry that, people would want to do the program. And it also brings in lots of different strands. So, there is a technical strand. They actually do need to know quite a bit of law to be able to do it well. Thank you. There is, the psychological human factor element that you could bring in. There's organisational structures and how to work with those. There's a whole range of things you could bring in to this sort of specialised degree, rather than what it is at the moment, which is a sort of subcategory often of computer science. And the problem with that is that people think of cybersecurity as all the technical bits of the problem, right? They learn, how to hack this particular kind of program and how to get around that particular network security, etc. Whereas everyone in the industry knows that cybersecurity is not just a technical problem with a technical solution. You actually need to understand it holistically. So it seems to me that's a really easy example of doing this. So my question is, well, is computational law something, if not now, then maybe in the future, that we could also think of as a specialist degree? Now, there are critiques. The two main ones that I draw out are the sort of who decides stuff. So, in established disciplines, there's a sort of body of knowledge that everyone kind of agrees these are the things to know. And if you go outside of that, what goes into these degrees? Is it just whatever I think? There's less of a background of study in it. The second sort of objection is it not as serious? Is it sort of teaching students to be dilettantes? They're never going to be sort of grounded in a discipline. They're just going to have these little bits of strands of knowledge. My answer to that one is kind of like, well, it depends on what kind of boundaries we treat as serious. We treat disciplinary boundaries as serious because we're used to them. Doesn't mean they're always the right ones. And also, you could also, quite frankly, make the degree longer. Already in law, there are degrees that are 7 years long. You can be as serious as you want in 7 years, I think, and teach most of both courses. But unlike a dual degree, you'd be teaching them in a more integrated way. So at least from an Australian perspective, you could be very serious and sort of cover both degrees and take them seriously, but have units and subjects where they could integrate them along the way. So thought bubbles, but very interested in people's reactions.
Great, thank you so much. And now we have a response. And now we have the response from Floris Bex.
I'm still typing in my response, thank you. Very good. Yeah, thanks a lot for that presentation and also for the paper. I was great interested. I read your paper on interdisciplinary education. I myself am a product of interdisciplinary or multidisciplinary education. I've studied cognitive artificial intelligence for my bachelor's and master's. When I say artificial intelligence, many of you might think, oh, that's that's computer science, right? Oh, there we go. But cognitive artificial intelligence actually is a collaboration between computer science, philosophy, linguistics, psychology, and provides courses on neuroscience next to programming courses, philosophy next to formal linguistics. So that's a very broad program, and one we're very proud of in Utrecht, where I work, and where I'm also involved in the AI masters. But I see other. I think Groningen is one in the Netherlands, at least. I don't know outside the Netherlands, is one that also does the cognitive aspects of AI very well. And this is also where the first challenge rears its head when we think about interdisciplinary law and AI education. Now I say interdisciplinary when I mean you could also substitute for multidisciplinary, transdisciplinary. Let's not debate that. I'll just call it interdisciplinary, right? But one challenge is that AI in itself is, or at least, or it can be, a very interdisciplinary subject without taking the law into account, with sometimes very conflicting opinions and ways of doing things and ways of how things should be done. For example, the philosopher debates the nature of intelligence, but the engineer doesn't care about whether it's intelligence or simulated intelligence or whatever, as long as it works. And this sentence is literally from the well-known textbook by Russell Norvig, right? So kind of most AI researchers don't really care whether it's intelligence, simulated intelligence, whatever, as long as it works. Well, and there's also what you see now, the technically schooled deep learning adepts like Joshua Bengio. He's one of the fathers of deep learning and also a recipient of the ACM Turing Award, so very much a kind of technically focused guy. And he fundamentally disagrees with, for example, Gary Marcus. Most people do, but that's by the by. And so kind of about the role that symbolic reasoning or explicit symbolic reasoning plays in human intelligence. And Gary Marcus was originally trained as a psychologist and not as a technical person. And also in our master's program and bachelor's program as well, I see a new focusing on machine learning, new students, of course, because that's the thing now, that's AI, right? Otherwise I'm not doing AI. And they have little interest in logic or philosophy. We have a mandatory philosophy course, but they kind of, they kind of go through it, having to do it. But equally, there's also students who graduate from our master's program with little understanding of the mathematics or engineering involved in deep learning models. If you want, you can choose your logic and philosophy and other courses, also technical courses, very technical course programming, kind of sidestepping the sometimes complex mathematics and engineering involved in deep learning models. So you can come up out of an AI program being, well, I wouldn't say monodisciplinary, but more or less, right? And in law, the differences may not be so great as in AI, although I've recently heard the phrase, I think it was last week, we welcome many disciplines today, criminal law, private law, and so on. So there's maybe also many disciplines in law. And many of my law colleagues, if I talk to my law colleagues, and they always look at their colleagues from another law discipline with amazement and incomprehension. Oh, these silly private law guys and gals. Like, no, I don't know how to do it in criminal law, but in administrative law, we don't do it like that, right? They're kind of very distinct islands of disciplines, even within just the law, right? So I guess the point this leads me to is that a large percentage of students and academics and people in general are, and always will be, monodisciplinary for different reasons. It's easier, It takes less time, you can make a nice living, or you can even make a very great career without straying outside of your discipline, and that's fine. And it's not just, I mean, I'm not very skeptical about this, that people just do it because of their career. No, a lot of people don't really care about other disciplines because they're just interested in one thing, right? In English literature or in computer science or whatever. And I think that's okay. People are happy to be monodisciplinary, and that's fine. But truly multidisciplinary work, interdisciplinary work will always be a specific niche. But it may be a niche, but I think it's an important niche nonetheless, and with valuable people in it, you guys, I guess, and us, that we should treasure. So if we can just say, I don't know, 5% of our students to follow the interdisciplinary path, that would already be great, and the rest can just go on with our monodisciplinary stuff. But the interdisciplinary people, we can use them as kind of hinging points, talking to both disciplines. For the others, they might be monodisciplinary, but they at least need to have, I think, a basic understanding of the other discipline, right? So to kind of make sure that they don't make the silly mistakes that you pointed to, Karen Jung pointed to, about AI. But the question is, how can we achieve that? And you mentioned 3 approaches, so adding in computer and data science in law programs, creating transdisciplinary classrooms, and building interdisciplinary programs. Well, adding in computer and data science to law programs, I think we need to think exactly about what we want to teach. I often hear people saying, they need to be able to program, give them an introduction to programming. And that might give them some basic computational mindset, computational thinking skills. It does not give them a good understanding of, for example, the limits and capabilities of legal prediction. So a more general introduction to AI course, maybe with programming and data science tutorials included, might be more suited. And also, I think we're just talking about teaching computer science to the law, but also we can also do it the other way around, so engineers about the law. In Utrecht we have a popular undergraduate course, Law and Informatics, and we teach computer science students the basics of Dutch law, and particularly the law that they might encounter in their careers as engineers or tech consultants, like contracts, data protection, intellectual property, those kinds of things. And I believe that offering such introductory courses to a fairly large population of the undergraduates that's achievable, I think. I mean, if you can convince your dean or whatever, dean of education, we have this nice course and we want to offer it to at least 40% of the students, I think you can get away with that, and that's a possibility in the bachelor's courses. Well, then the transdisciplinary classrooms is, I guess, more difficult. It requires yet another course with input from another discipline. And they cannot be a basic introduction courses like the ones I just mentioned, but should be kind of more problem-driven, engaging the students to solve a problem by collaborating. For example, let's all work together on developing and using legal technology. And this would, of course, be for the niche of students who really like to do this kind of interdisciplinary work. And with the large number of law and computer science students and the pressure on education already being very high, developing new courses for, let's say, 20-odd students is not something that can count on a lot of supporting your average law school or computer science department, I think. And the same goes maybe even more so for interdisciplinary programs. I mean, if you really want to do that, people will say that's fine, but do it in your own time, right? I mean, we have 800 law students waiting there for you, or 500 computer science students waiting there to get the basics of their own craft and not your problem-driven niche stuff, right? But, I mean, interdisciplinarity, or at least a basic understanding of the other discipline, is not just about teaching the other discipline to students in courses and programs. I think it's also by the academic staff needs to live it, in a sense. We expect students to understand the law and engineering, but many of our colleagues have no idea what's happening on the other side of the fence. So I've lost count of the number of times, also, as you said, Karen Jung, I heard respectable law scholars, also respectable law and tech scholars, I won't name any names, argue about the kind of magic of deep self-learning systems at every turn, and not taking into account more than 90% of actual AI is good old-fashioned rule-based systems, with its own problems and advantages, but still. And similarly, there's too many AI scholars that talk about ethical, legal, and responsible systems without having any idea of the role that law plays, or should play, when thinking about these systems. So, should we not also provide further training for our colleagues? Should we not, anyone teaching law in the broadest sense, at least follow a course to dispel any myths and misconceptions about what AI or algorithms really are? And should not anyone claiming to teach responsible AI and looking at the programs in at least the Netherlands. That's about everybody in AI these days. Follow a course on what the rule of law, for example, or ethics really means. So interdisciplinary education has to fight an uphill battle against the forces of monodisciplinary research conservatism. So spending time on education and developing courses and programs, let alone niche interdisciplinary education, does not make one a full professor very quickly. But I guess we're slowly advancing. I mean, this research is becoming more popular with great examples of funding. Giovanni had an ERC program. This is, of course, Cubicle, okay, is of course a nice funded ERC program. We have collaborations and conferences like these, and I think that it's slowly gaining some traction. And we're effectively, as you say, for criminology, creating a new discipline, computational law or AI in law or whatever you want to call it, to help researchers and the international academic community accept this type of research and come together. And if the research changes, so this will create the kind of the environment for the new colleagues to also create new education. And that will take some time and that takes some perseverance, but I think we will get there at some point.
What would be really great right now is if somehow we could have someone discuss the next step after this education, like transdisciplinary research as a way forward in AI and law, and by a wild coincidence,
That's
we
me.
will now have this presentation from Professor Bex.
Can I keep sitting down and start? Is it there? It's here, and I double clicked it. Wait. Needs to start. And then we do 5. And then can I use this picture too? It's next to you, yeah. Yeah. I think I'll just go sit. This is not me, right?
No, that's not true. It's nothing.
Preschool interdisciplinary.
That's interdisciplinary training. That's right. You got to start early.
Start
with
at preschool.
interdisciplinary training. At 3 years old, we can win them over.
Yes, it does. Thanks. Does this work? Yeah, it does. Oh, yeah. All right. Good. So thank you, and I thank you everyone for inviting me to this year's Circle conference. I had to look it up, but it's not CRCL, it's Circle. But I'm very happy to be here to discuss with you my field of AI and law, which has already been discussed a little bit before by Giovanni and Dennis, and also how I see us moving forward in today's what I call algorithmic drama. Right? You have techno-optimists, techno-pessimists, deep learners, good old-fashioned AI people. They all jostle with each other for money, time, people, and legislation in today's AI opposing sides drama. Well, as president of the International Association for AI and Law until this December still, I'm representing my community here today. I'm not the only attendee from this community. We had Giovanni here as well. Katie Atkinson is one of the organizers. Unfortunately, she couldn't be here today. But we have a few community members here, but I feel like I'm representing this community as the president of the association. And as Denise already astutely observed, AI and law is very much a kind of techno-optimistic community of computer scientists and tech-savvy legal scholars, mostly distinct from the law and tech community, more AI for the law, developing AI for the law solutions, and less law for AI. This field we've been around for quite a while, at least since 1987, when the first international conference on AI and law, ICALE, was held in Boston. And these were the days of the previous AI hype summer, as it's called. The legal expert systems based on logic were set to take over the legal profession. Robo-judge 1.0, if you will. And it's nice to look back at these days of the legal expert system, have a look also at these papers and also the work by, for example, Richard Susskind that's been written then, And the echoes you see of those time now with, of course, ChatGPT, and I think it's going further. But you can very much see that that was also a time when everybody thought AI was going to take over the world. So what we did as a community, we persevered through the ensuing AI winter when no one was interested in AI anymore. Every time I started my studies in 1998, and every time I told the kind of generic uncle at a party, what do you do? AI. They said, ooh, artificial insemination. I mean, it was that kind. It was that bad, right? I mean, I couldn't say I did AI because I would just say, oh, I do computer science, because I didn't want anyone asking weird questions. But now I say, of course I do AI, and people start throwing money at me. So that's good. So, and this summer we had our 19th IKIL conference in Braga, Portugal, with a record number of submissions, many, of course, on machine learning and legal language processing, and ever-increasing interest also from the legal sector and law scholars. And I think the AI law community is certainly not just the IKIL conference. We also have there we go. Yes, we also have a journal. This is pretty small, but in my paper you can see the full reference. AI and Law Journal recently celebrated its 30th birthday. I think Denise also already referenced it. You can see a lot of the work that's been done over the last 30 years in the journal and published. And we have also many new and old connections to other communities, similar communities like this one, of course, also Jurix, legal language processing, Codex Future was also mentioned before. At the Society for Empirical Legal Studies, we had a separate track at the last conference, how they can use or leverage maybe AI techniques to do their empirical legal studies. And I think it was 2 weeks ago, I was already also in South Korea, or Korea as they call it, at the Seoul AI and Law Symposium, where they're also kind of really developing a lot of thoughts on AI and law. But in the end, we're just one group of researchers in today's AI landscape, where multi-billion companies and huge countries are the kings of AI, and everyone has an opinion about AI or how to deal with this. And this kind of summer of AI that we're in now is definitely heating up. So the question is, how can we as an AI and law community, and this includes also present company, I think you are the AI law community, or should be the AI law community as well, how can we deal with this kind of summer, almost global warming in AI we have now? There we go. So I argue there's 3 points we need to take heed of. First, we need to combine research on data-driven systems, so machine learning, large language models, generative AI, with research on knowledge-based AI, so good old-fashioned AI. Of course, we should use these new deep learning techniques, but we shouldn't forget about the old-fashioned AI and law. And one point is that AI law has most of its history been dominated by symbolic knowledge-based AI. Also what Giovanni Sartor showed you, his kind of road from the 80s until now. Argumentation, knowledge-based AI, pre-programmed knowledge, logical models of legal argumentation, logical models of case-based reasoning. But the successes of legal language processing and generation have changed the core research, and it's now mainly focused on data-driven AI that learns to kind of recognize patterns in the noisy data that knowledge-based AI techniques have always struggled with. But one of the problems is, and I said it before as well in my reply to Lyria, many people think that machine learning is the only kind of AI, or the only kind of relevant legal technologies, if you will. And I think we shouldn't forget about knowledge-based AI. We did some work with the police also in kind of a bounded domain, and provably correct and transparent legal reasoning is important, and knowledge-based AI techniques, I think, still reign supreme. So I can give an example of that. And I won't go through the full example, it's in the paper, but one of the things we do is we have a system where if people come up with a complaint form and they say something happened to them, this is about fraud online, right? So kind of malicious traders online on eBay or whatever. And we use some data-driven AI to extract the observations from the complaint form, but we use to kind of infer whether it's possibly fraud or not, we use argumentation. So reasoning, it's a decision tree, but it's a decision tree with also exceptions to rules are possible. And we ask for missing observations, and that's partly knowledge-based, but partly data-driven as well. And before we started, this is a 2022 paper. We've been at this at the police since 2016. And when we started, we said, can't we just do it kind of end-to-end data-driven? Just give it the complaint form and then have it start asking the right questions without all this kind of, these rule bases underlying it, all this kind of complicated stuff, knowledge-based stuff. We have to program the knowledge into it. We don't want to do that. Let's just, the system speak for itself. Well, that didn't really work because it couldn't. It just recognized some correlations which were not very helpful. Because whether something is fraud or not depends on the Dutch criminal code and some kind of policy rules the police has, and not on whether there's a correlation between, the name of the people filing the complaint and whether it's fraud. Right. So, I challenge anyone. Well, there's not too many technical people, I guess, in the room. But if you're technical and you say, well, I can do this with an LLM easily, the challenge is on, right? So I think in these kind of bounded domains where we want to do legal reasoning, I think knowledge-based techniques are still kind of reign supreme, and they're very, very important. Going one step further, I think in the quest for transparent and scalable AI, that can perform legal reasoning and handle noisy and open textured concepts, we should combine data and knowledge in what are called, kind of fashionable term, neurosymbolic systems. One way to do it is like this, where you have the input that's noisy and open textured kind of read by the data-driven system, and then the knowledge-based system to reason with this. But there's also more available, for example, injecting knowledge into machine learning systems. And actually we've developed a system, it's not on the slide sadly, but we've looked at ways of, can we have a deep learning, a neural network do the argumentation and explain this argumentation itself. And we've seen that well, not these complicated, this is too complicated, but simpler possibilities are there. And I think one of the earlier speakers said about the kind of bitter lesson by Sutton, that more data is always the way forward. Well, actually, another machine learning expert, Max Welling, a Dutch guy, he replied to this that some sort of human knowledge will always be needed for AI. So it's kind of, some kind of knowledge will always need to be injected in these large data-driven systems. I mean, all the guardrails and all these kind of guardrails that large language models have, a lot of them are kind of symbolic, or are at least human knowledge explicitly programmed into the system. And the second point I want to make is, I think I need to hurry up a little bit, right? Yes. Okay, so put AI into practice, legal practice, by working together with courts, police, law firms, but most importantly also citizens, as we've seen by previous speakers. So testing our AI models using carefully cured test data sets, or even by just measuring them against our intuitions, can only take us so far. That's nice, but we need to implement prototypes of AI systems and have them used by disinterested domain experts, as someone in our field has called it. Lawyers, judges, law enforcement officers, and citizens. And I know from experience working with practice is very hard. Much of your time is spent on keeping practitioners happy and engaged with a prototype system that might never be used in practice. A lot of the work you do might never be published, kind of building a system or making a button a little bit to the left or to the right because the users like that is not something you can publish about at conferences and journals. And there's the organizational realities. I agree with Hildebrand's question. So what problem are we solving? Can we unravel these questions? What problems are we created? But capitalist realities are such that we need to move on, right? So we need to build the system. The budget's here now. And if you spend kind of 4 months doing your academic thing, unraveling the problem, then the budget's gone. So we need to move, right? So that's very difficult. But as we've seen also with police and the courts, it's very rewarding and leads to more research. If you spend the time, it's a long game. So at first you will do lots of things that don't get you any publications or any kind of credit, but at some point you are the only one that has a system in place at the police or at the court that can do really interesting research, not just user friendliness and accuracy, but also the effect they have on society and the organization. Oh, and just one back. Finally, I think that's also coming back to what Lyria said. We need to work across disciplines. So bring together those who think about how to build AI and those who think about how to govern and regulate it, and going beyond AI and law and reaching out to other disciplines. So we worked with people from management and information sciences, and they allow us to see kind of the bigger socio-technical systems surrounding technology. People from psychology, public administration look at our technology through an empirical lens. More critical humanities, philosophy, ethics, but also communication and media studies question some of the core behaviors and ways of communicating that our community takes for granted. Right, so I mean, like working with practitioners, this can be very frustrating. You spend at least as much time trying to understand each other's language and way of thinking as you are trying to solve actual problems. And more strongly, solving the problem might not even be the goal of the other party. I mean, computer scientists and also legal scholars, I think, we're focused on problem solving, but empirical disciplines may look at what's the actual problem. And well, are there people with a kind of more critical theory background here? You could say they're there to create the problems, right, in a good way as well. So we've seen that. I mean, the only way to really kind of design and evaluate this stuff in practice is to use different perspectives, different methods, so computational, legal, experimental, ethnographic. And then that's almost it. Oh, so yes, so these are my three points, and I invite you to talk about this. And as a final point is, I would also like to invite all of you to our home, which is very close by in December. There's the Zurich conference. It's a kind of a European version of the ICAL, the bigger ICAL conference on legal knowledge and information systems. It's in Maastricht in December. So even if you don't have an article, or even if you think, oh, that's a lot, it's too technical for me, come and join us and come and engage in discussions with us about how we should employ legal technology. That's it.
Thank you. And now we'll have a response from Gianclaudio Malgieri.
Yeah. I hope this goes well. Let's try it with both.
They have to wait there. They have to switch it. I think.
Okay. You think this works? Yeah. Just go on. Okay. So yeah, it was a real interest. No. I have to keep it. Okay. No, just closer. Okay. Like this?
Yeah.
Okay. So yeah, I mean, first of all, I'm very happy to be here and to comment on this paper. It was a very nice and funny challenge to engage with your narrative. And first, I would like to start from the title of your paper. Since you were just saying this a few minutes ago, commenting on Lyria's paper, multidisciplinary, interdisciplinary, transdisciplinary. Mireille uses a lot cross-disciplinary. I think they are not synonyms. I like to explore words, and I think rightly you said transdisciplinary. So multidisciplinary makes me think of an additions, multi, as many groups. Inter makes me think of something that is in between. It's an interspace that you cannot define whether it's more left or right, whether it's more law or computer science. And I think most of us have experienced that feeling. With being an interdisciplinary person, you are considered the lawyer by the computer scientist, and you are considered the computer scientist's appetite guy by the lawyers. But transdisciplinary, trans is a transition, so it's a movement, it's dynamic. It's or cross, so it's a bridge. It's like Sharon for the ancient Greeks. So basically, it's bringing the fields together like actively. And I think a way to do that I'm learning, and I learned from your paper and from the whole conference papers, is to focus on methods. Because I've usually not focused a lot on methods. I've focused on problems, ethics problems from a legal perspective, and I tried to address these problems, not just looking at methods. And then, after a long journey on unsolvable problems, I understood that maybe the best way is just to look for different methods. And this goes to the conclusion about different methods you're mentioning: ethnographic, computational, experimental, and organization, cooperative, you said, some participatory. Sorry, I was too many adjectives. But so just like to rebuild your journey. So you start from two starting facts, I would say. So a factual fact is the algorithmic drama, and I think we see a lot this algorithmic drama these days on the news. Just to be like some Altman story or the AI Act trialogue. It's everything related to AI seems a drama, but actually I think it's also connected to the large use of different forms of AI in practice. And then an opinion fact. Your opinion fact is that the field of AI and law is largely techno-optimist. So I was wondering on myself and my colleagues, are we really optimistic? Are we part of that optimism? And I thought, I'm not sure. I see a lot of AI cynicists. I see a lot of possibilists, potentialists. I think most of lawyers that look at AI are pessimists. I mean, this is interesting, this discussion, because maybe from your background there is this idea that AI can solve its own problems. I mean, or at least you mentioned the narrative that was there, while I think there's a large part of, let's say, legal scholars that mostly look at the problems first. And you said something very interesting, that we focus a lot on machine learning, but knowledge-based AI was a very interesting example of how you can really play with the concept. With the two projects you mentioned, it was super interesting to find that in the example of the police, as you mentioned, the policemen and police people were not following the advice of AI, were not following the suggestions. They wanted a better process, but not a product. So they wanted AI as a powerful process, but not as a final product. And so first I had some questions about the research, because and this may be a question for later. Was there a bias in these police people, in these policemen, because they were used not to use AI, so they were used to make their own reflections, so they want a reasoning. But what will happen in the future, where police people will be used to have AI also as a product, as a semi-automated decisions? They will not be they will be used to have maybe all the process, all the AI-driven process there. But there is also something else, because I think there was, as you said, this problematic neurosymbolic system discussion. So they wanted their reasoning. The police people wanted to understand and make their own decision. They didn't want a final output. And so this is connected also to the discussion on human oversight, human out of the loop, in the loop, human in control. Maybe we can say human at the end of the loop. Just to say, I found it super interesting, this findings about how the relationship, the narrative about use of AI is actually a very false narrative. And again, coming back on methods, as substantial lawyers and not really looking at methods, why I think that methodology like, for example, participatory or ethnographic methods can be a solution for many problems. Because actually, we had similar example. I worked a bit on a lot on vulnerability, and we were focusing a lot on how you could really solve the problems related to vulnerability with substantive law and solutions and fairness in practice and no-go zones, all these normative solutions. And then the biggest solution was suggested by Algorithmic Justice League in the States. They suggest participatory methods. Change the system, the problem is not the law, the problem is who decides, the problem is who is at the table. So again, methods over the results. I think this was just to nudge a bit provocations. Maybe I went far away from the paper, but this was at least what it inspired in me. So thank you.
Will Frank be joining us?
Yes.
I think Frank has joined. Frank has joined us. Wonderful.
Yeah, and we have a presentation to launch, or maybe Frank can share as you wish. I can go.
Yes. Can you see it now? Can you see the presentation now?
No.
No? Okay, I'll do it again. Then no problem. I'll go on here and do it again. One sec. Oops. Okay. Almost there. Got the presentation. Does this work?
Not
No.
yet.
Yeah.
Okay.
You want to?
Very good.
Yeah.
Yeah, so shall I just jump in?
Yes.
Great. Okay. And I get a little bit of feedback from my headset, so I will just take these out a little bit. I am just thrilled to be here. I know that we only have 10 minutes, so I will make sure that my slides are in 5 minutes. And I will be going forward with the explanation of our approach, which is on generative AI, explainability, and score-based natural language processing. And I'm particularly happy to present this today because there's so many connections, both to prior presentations and to the recent one. For example, I mean, in Floris's paper, he mentions the ethnographic case study of the Department of the Dutch Police that has incoming citizen reports on alleged online trade fraud, and about how these online reports are, there's no explanation, which is fascinating, and it goes into exactly the type of issue that we're going to try to address in this presentation in our paper. So I need to give you some background on U.S. disability benefits before getting into the meat of this. And basically, there's something called Social Security Disability Insurance in the U.S. It's one of the original mass justice systems. And in a study of 1 year of SSDI claims, out of 1 million, only 36% were initially successful, but 59% were ultimately allowed. So we're talking about hundreds of thousands of people that are waiting for their disability. And this has led to some urgency, for example, in a report by Engstrom and Ho and Cuellar and Sharkey. It's a major report for the U.S. Administrative Conference. They've talked about we've got to automate some of this stuff. And the question becomes, how would you do that, right? How would you automate determinations? Well, there's some really easy low-hanging fruit out there that has already been addressed, okay, even 7 years ago or 6 years ago. And that is, for example, the compassionate allowance initiative that allows for computers to identify a subset of the most pressing listed impairments, okay? So for example, if you have a listed impairment, if you have one of the conditions that is really disabling, a computer can just see that in your medical record and just pick it up. It's text matching, right? And there's the article in the JAMIA, Journal of American Medical Informatics Association, on exactly that. You can sort of see the workflow here, right? Thinking about disability application, string matching, and expedited service for those that are, for example, being identified as having one of these listed impairments like glioblastoma, which I mentioned on the last slide. The idea behind here is, behind expanding the program, could be that you could have new natural language processing that would identify things that are like that condition, right? Now the question becomes, could these types of compassionate allowances be expanded further, right? Could we go from text matching of particular conditions, where the condition itself is predicate for disability, to situations where the totality of circumstances indicates a pressing need? What we describe in the paper is, for example, imagine a situation where if you had 6 moderate illnesses, these 6 illnesses would always lead to disability. Well, a scoring system whereby you needed 100 points and each illness resulted in the award of 20 points, that would be 120 is greater than 100. Therefore, on this points-based natural language processing, you get your benefits, right? So you could imagine that sort of thing. And I think now, of course, there's many difficult jurisprudential questions about what exactly that assignment of points is. And of course, I heard earlier Genevieve's intervention in the last panel, and I'm so glad she's here because, you know, her work on the normative value of legal analytics is so helpful in terms of this idea of the nature of the statistical precedent here. What we're looking at initially is just something that would say be a version of, say, immigration systems where they give you a certain number of points for, say, having a job, speaking the language of the country you're immigrating to, all these sorts of things, right? But of course, that could be complicated. That could be complicated quite a bit. And the way that we try to propose the possible complication or anticipate the possible complication, we're not really proposing this, we're just trying to anticipate and respond to it, is the idea that software can be programmed to code certain languages, either indicative or not indicative of disability, and you could assimilate that language to numerical tractability. To give an example here, also an image from the paper, imagine Desmet et al., in an article called Development of NLP to Support Determination of Federal Disability Benefits, have described this sort of coding for polarities, where either the word ambulate, for example, would code against a person's disability application because ambulate indicates some form of ability, but the fact that they need a front-wheeled walker and can only go 300 feet, that polarity is for disability because it's a quantification and qualification of the original one. So our idea here is that it's quite possible you will see disability systems trying to move from, say, that type of polarity coding to score-based NLP. Okay, and the question becomes, and this will set up, and I see I'm on exactly 5 minutes, so this is perfect for timing. If scoring became generalized and machine learning driven, I should say driven, not drive, machine learning driven, could we move from natural language processing to natural language generation to rationalize the scoring, right? So we could have increasing pressure to move from scoring to find the neediest cases to more general scoring of applicants with a cutoff for eligibility. And if we did that, is ChatGPT posed to deliver the automation of justification? Okay, so that is sort of the idea, and I can keep the slides going for Gianclaudio, or Gianclaudio, if you want to manage the slides from your own computer, whatever you'd like. But I'll pass it off to Gianclaudio now. So thanks.
Yeah, maybe it's easier if you keep the slides and I ask you to go on, just to avoid too many changes. So if you just go to the next slide, it would be very helpful.
Yes, I'll do that right now.
I think you were yeah, they just put you out from the screen, but we will see if maybe you are coming back.
Yeah.
Okay, great. So thank you so much, Frank. It was a real fun, honor, and pleasure to work with you on this. And maybe I will sacrifice part of my 5 minutes for an anecdote. As I told before, I was on a lot on vulnerability and digital vulnerability, etc. And I had this discussion with Marta Feynman last November, 1 year ago. I said, you know, your idea of vulnerability is wonderful. She advocates for universal vulnerability. The state should be responsive, and we are all vulnerable, and the state should take into account your welfare problems. So, for example, the vulnerability issues that Frank was mentioning. But the problem of universal vulnerability is that it's very hard to operationalize it. If everyone is vulnerable, how can we really operationalize it? How can we help the more vulnerable, right? And Frank was making this wonderful example of a scored-based NLP for helping to solve and also to prioritize. Well, this was not an anecdote, it's just a bridge maybe, but to prioritize the highest case of vulnerability. So AI can be not just a tool for vulnerability, but a tool for empowerment, a tool for mitigating the highest priorities when operationalizing vulnerability mitigation. But there is a problem, right? We need justification. If there is mass scoring, mass operationalization of welfare benefits, we still need to explain why some people were excluded or why some people were included in a particular way. So here the intuition that Frank had and that I followed was, can ChatGPT or generative AI be used also in the justification process? So in the production of explanations, in the production of a justification. We know that justification has at least 3 functions, right? Dignitary, because we as human beings want to know, have a right to know from humans or from quasi-humans what is happening. Enabling function, because if I can have a justification or an explanation, I can act. I can exercise further rights. And fairness, accuracy, accountability. If I can explain and justify, I, public administration, know what's happening. And if I am forced to justify, of course, I should do some internal impact assessments, on internal homework. Next slide, please. I think it's frozen.
No.
Yeah. So in public administration, justification have also an additional level, which is administrative due process. So actually, we have a constitutional and fundamental right to know what the public administration decides as a result of administrative due process, because here the counterparty is not a normal, it's not a big tech, all the problems of big tech. Here the counterparty is public, and public means that there are, of course, some duty to give back in a way, so to explain and justify. So next slide. Thank you. So well, here was the thing. Can we use ChatGPT as a solution? And next slide again. Yeah, again. So there are some benefits. I don't know if you can read from there because there's a bit of but the benefit is, of course, efficiency. The problem of generating justifications is that it might be misleading and artificial ex post justification. So it's result-based justification. So it might be interesting if this is the opposite of the example of police. So here is not the police understanding the process, but it's the process understanding why the police did something and explaining it, right? So here is ChatGPT should understand why a score-based NLP decision was made by public administration, etc., and it should justify it. There are many problems here, of course. Just next slide. It's just a redundant slide saying that all the problems where all the principles are at risk if we use ChatGPT. So we recognize the benefits of, and this is optimism in score-based NLP for administrative welfare benefits allocation. But at the same time, we see the problem in justification. And so maybe last slide. It was impossible to have an updated slide since things are changing. Just this night, there were developments on the AI trialogue and on the regulation of AI and on foundation models. The trialogue is really going to crash, or not, maybe not to crash, but it's going to be problematic. So just this night, France, Italy, and Germany circulated a paper, a non-paper they call it, for the no regulation of the foundation models in the AI Act, and they propose to have just mandatory self-regulation in the AI Act for foundation models. But just to make this example, if we look at the AI Act without foundation model regulation, our example is not covered, because the AI Act covers the uses of AI systems, and the use of AI system by ChatGPT in the administrative stage, welfare allocation or judicial decision is just for scoring. There's no high risk for explanation given. So if public administration uses generative AI for giving you a fake explanation, this is not covered by the high risk list or the or the Article 5. That's why we think it's not just the uses that should be regulated, but it's also the process or the powerful tools, because there are many unpredictable effects. And I think this is the end of the provocation. Thank you.
Thank you. So this is a response that's going to combine elements of the paper that weren't as big in the presentation and elements of the presentation as well. So it'll be a bit of a combination from those two things. Thank you very much for the paper, in both formats. Really interesting and really enjoyed it. One of the sort of points made more in the written paper was this idea of, and to some extent of the presentation, but it came out more, I thought, in the written paper, was this idea of the sort of emergency scenario, right? Like you need to expedite because people aren't getting their welfare benefits and, therefore can't live in the meantime. And this sort of use of systems, if you like, for that kind of do good. And it's interesting, and I keep using Australian examples, so I'm apologising a little bit for that. So Australia is very well known for a sort of do-bad system, right? We had robo-debt, I think everyone's heard of that now, and it was terrible. But it's less well known for some of the problems in a do-good program. So the do-good program, which was also kind of based around that same idea of timing and prioritising and how you do it, was a program that was operating in New South Wales revenue. So this is the state-based sort of debt tax collection-y type of unit at the state level. And one of the things that they're responsible for is collecting fines. So you park illegally, you speed, you do that kind of stuff, you get a fine. Some people just pay it, and that's fine. And then some people obviously don't. And there's a very long list of those, and they have to try to work out how to prioritise the debt collection process. So originally, of course, they just did this sort of in the order of date or whatever, and you go through. But they decided that they would actually try to use, and in this case, it was a machine learning system to try to do good. And what they wanted to measure, funnily enough, because you mentioned the same term, was vulnerability. Who is vulnerable? And we want to try to work out who's the most vulnerable so that we can collect debts from people who are not vulnerable first, right? So if someone's a nice, happy middle-class person, we go and send the debt collectors after them. And the people who are vulnerable, people who might suffer real consequences from having debt collectors after them, they will go to the bottom of the list. The problem with it, though, is that even at that level of a sort of do-good type of mindset, there's a lot of questions, right? How do people, what are the variables being used? There was no transparency, there were no reasons given. In fact, most people didn't know this program was running, so people didn't even realise why their debts were being collected now and maybe their neighbours' debts weren't, if they even thought of that question. But also really deep questions, right? So whatever the variables are being used, are they picking up female vulnerability and male vulnerability, which can look quite different equally? Are they picking up Indigenous vulnerability, which is a very small percentage of the population? If it's a very large model, there might be different factors there and they don't pick it up. So I suppose the sort of first point was that kind of caution about the sort of do-good element of it. And even if that's what you're trying to do, you kind of still come back to the same problematics. A second one is the sort of speed problem. And the risk, and again, an Australian example, but the risk that the need for speed gets used as it sounds good, like we will give these people faster service, etc., but actually gets used for a very different political agenda. Example from Australia is the fast track process for refugee processing, which was designed to it was sort of sold on the basis of, well, this will help make decisions faster and give people answers earlier, etc., but was actually a sort of backhand way of bypassing administrative protections for people going through a refugee determination process. So I'm sounding very sceptical and very non-optimistic, but these are the sort of examples that I think are worth worrying about. But my next sort of thing I wanted to sort of raise in a different dimension is how, the idea of aligning whatever ChatGPT produces, which seems to me the real challenge with it, right? Like whatever ChatGPT produces is not the mirror of what the actual reasons for decision are. It might fool someone into thinking it is, but it isn't really, there's all sorts of modelling problems. And I think ChatGPT is particularly bad at this. But I'm also wondering, and sort of building in Floris's comments as well, like what is the way to do this well? Like if ChatGPT is not the solution, are there other ways of doing it well? So one way is you have a knowledge-driven system, and knowledge-driven systems can come up with reasons and explanations from that knowledge set as to why they did particular things. So, a lot of the sort of expert systems will automatically generate a set of reasons that will explain a decision based on the knowledge base. But I'm curious because one thing I read a while ago was some of the sort of mathematics, like Judea-Pearl stuff, right? The mathematics of causal modelling that could be at least partly data-driven, right? In other words, that you had to have some advanced knowledge, but you didn't need to have the full advanced knowledge. You could use the data in this sort of mathematical language of causality to determine likely cause and so forth, or exclude particular causes. So I'm wondering what a system might look like that could generate reasons that were sufficiently accurate reasons for the logic of the decision-making process, and whether something like that could be a sort of data-based, data-driven kind of way of doing it. I think, though, whatever it is, there's another problem too, and it comes up, it's talked about more in the context of the sort of AI judge, but it still kind of comes up in the administrative context too, which is part of the dignitary reason for wanting reasons is actually that you want to see that judgment has been exercised. So people talk about this in courts, right? You want to actually have a sort of written demonstration of understanding they've turned their mind to it, they've thought through it, they have exercised their judgment based on precedent and all the legitimate kinds of reasons they can take into account, and they've come to a decision. Now, administrative is, a little bit not quite the quality level of a typical judge decision, but some of the same sort of logic applies, right? You actually want it not just to be accurate. So even if you could model the causal reasoning and produce it that way, it would not actually be itself evidence of exercise of judgment, right? It would still be the sort of automated system, and whether that would undermine certainly that sort of dignitary point, treating people as deserving of reasons. Am I running out of time? No. I'm good. Okay. So that was sort of the next point. And the final one I wanted to mention is about the sort of going back to those justifications, right, for when, why we want reason. So dignitary enabling, fairness, accuracy, and the sort of legality, particularly in the context of administrative law. And I think we need to sort of add an extra element there. And the final one about administrative law is part of that, which is when and why, right? So there are contexts in which we generally don't expect reasons, right? Certainly outside that sort of government context. So government, clearly, administrative law, reasons required, etc. But there are many day-to-day contexts in which I'm not entitled to reasons, even leaving aside the computational thing. If I go to an outdoor market, the kind where you get to bargain with people and they give me a really high price, I'm not entitled to demand that they tell me, was it the jewelry I was wearing? Was it, the fact that I looked innocent and non-skeptical or something? Like, you're not entitled to demand reasons. And similarly, there are circumstances, I would say, with computational systems that you don't, generally speaking, get to demand a reason. So the sort of European approach to regulation, and you see this very much both in the GDPR and the AI Act, is, well, you're entitled to certain things if particular technical things are done. So if it's an automated process, if it's an AI, if it's AI in the varying moving parts of the definition, then you're entitled to certain kinds of explanations, but not if those definitions, and they're different in different parts of the regulatory scheme, don't apply. I would actually argue that far more important to a very large extent is context. So the fact that it is a government decision and everyone is vulnerable to government decisions in a way that they're not vulnerable to whatever the seller in the market decision is. You can go to a supermarket instead if you don't like doing that. There's sort of a choice, there's a lack of choice that then means that we say that is a circumstance in which we want to have reasons. And I actually think that kind of a logic is better in some ways than the sort of, if it uses a particular, like if it's automated or if it's AI. In particular, given your point about the AI Act and the varying framings and what's included and what's excluded, you sort of take it away from that argument, right? We don't have to decide what this thing is. We don't have to worry about technical scope of the thing. Instead, we can say, okay, what are the contexts in which things, whatever the thing is, matters. So that's all.
Great. Great, and we have time for some questions. I'm going to use my moderator thing to just mention one thing that all this made me think of is there's a line of cases from, it was a little while ago now, where a couple of judges, it only happened a couple times, decided that their facts were truly in equipoise and they would flip a coin. And so we had literally, so that we had these reasons. There was a reason. This is like what you were saying earlier. There was a reason. The reason was they flipped the coin and the coin came up heads. And this was like totally unacceptable, and that they were told that in no uncertain terms by the appellate court, that can't be the reason because it's not a justification. And so I wonder, to the extent that we have probabilistic models underlying, it's both analogous and I think maybe connected. To the extent that there are probabilistic models giving you reasons, or is it really a justification? Or do we deserve, does the person who's faced with the exercise of the power of the government deserve more than that? So anyway, just a thought. So with that, questions, comments from the audience?
Thank you very much. Thank you, the four of you for your presentations. And I have something that ties in with the techno-optimist nature of the AI in law and the proposed solution to the US disability benefits that Frank and Giancarlo you proposed. So you have this policy which obviously has a design problem, which is that you have an application that has free-form inputs, and then there's an administrative review of these free-form inputs, which is bound to take a lot of time, right? But on top of the technological solutions to this problem that you put forward, there are also simpler administrative design solutions. For instance, you could trust a third party, like a doctor, to qualify the situation, or you could make the inputs way more detailed so that you could only file your application by ticking boxes and select predetermined inputs. In those cases, if you trust the application either with the filled form or the third-party qualification, then you could switch to a logic where you accept applications by default if the file is complete. Then you would obviously need a completeness administrative review, which is more quicker than the complete review that happens now. And you could also set up a control policy so that afterwards, if the application has been granted, you actually do in-depth reviews of the files to check that people actually deserve the application. What do you think of these kind of solutions?
I'm sure Frank wants to comment.
Yeah, sure. Yeah, I'm very impressed by that idea. I think that's a very helpful idea in terms of making the inputs more detailed and more structured. I like the idea of bringing a doctor in. I will say that, like, sometimes the doctor is, the doctors are very involved in this process already. And in a way, one thing I'm hearing you say is that perhaps this is something to be outsourced beyond the judicial system to some sort of expert who just makes a determination as to latent disability. The one problem, though, with the system, which is not reflected in our paper, which a longer version could have addressed, is that the disability determination is often an interaction of level of disability and the type of jobs available in the national economy. And that meeting those two, the intersection of the two, can be very difficult. But with respect to just the level that we were discussing, at what level is a illness completely disabling, there may well be very good grounds for moving that entirely to some type of purely medical determination, sort of along the lines of the progress of kidney donor matching algorithms have been moving in that direction. In terms of, like, at least in the US system, under the organ procurement transplant network and the other organ allocations, when a kidney comes up for donation, it's much of the determination has been outsourced to nephrologists, kidney doctors, who in turn have made a highly technical determination about antigen matching, about which potential donee has the right antigens to match with the donor kidney. And so it's a really interesting perspective, and I think it adds a lot to the paper if we were able to address that, and it might be something I'll have to address in future work, that interaction of medical and legal expertise. So thank you.
If 10 seconds follow-up is for inference, if we rely on doctors, but the Social Security also has doctors, and sometimes you have disagreements between doctors, but then there's a special doctors' disagreement resolving.
Yeah, so one point you mentioned is, this was also a question I had, maybe for Frank and for you as well, is Okay, so asking questions in a more fine-grained way, right? So in a form that one of the things we try to do at the police is ask fine-grained questions, right? So you can say, what's the number of the advertisement on eBay or something, right? And what's some kind of what we call metadata? You can ask that to the citizen, and they can input that. Why we did decide to keep this free-form text part, which needs some kind of interpretation by NLP, is because if you want to ask everything and the possible exceptions, then you get a huge list of. So we want to keep some free-form text, but then we have also the kind of the system asking questions to, this is what you input, did you mean actually this or that? And they can say yes or no. By the way, sometimes citizens even can contradict themselves, right? So they say, oh, I didn't get a product, and then, did you get a product? Yes. I mean, so that's a bit problematic. But anyway, going to that, the point-based NLP solution, I'm not sure how it works, but thinking about it, it should be possible to get some sort of, at least to point it to, that it points to factors. This is why you got 20 points, and this is why you got 20 points, right? Because we matched you with this disease, and with this disease, and with this disease. And then if you get that kind of explanation, that's almost kind of a knowledge-based, a fairly transparent explanation, I would say, right? Or am I wrong?
I mean, I can. Yeah, I mean, if I were to jump in on that, I mean, just I think that this paper is moving along a continuum, sort of like an assumed continuum of evolution of the score-based natural language processing. So what I would say in response to that is that it's true that on the simplest level that I can explain and that we can explain in the paper, that seems really clear. For example, that like the 6 diseases that each count for 20 points add up more than 100 points, and therefore you got the disability, right? But then if you were pressed for a better explanation to say why those 6 diseases and not some other combination of 6 diseases, right? Or why whatever the combination may be, that's the type of level of explanation that I'm guessing they might try to unleash ChatGPT on, or to try, given that it could analyze a huge corpus of cases, and I think that it's interesting to sort of think about that as a potential, like, clues to understanding how the score-based natural language processing might have elevated certain factors above others in its scoring processes to determine like who is the most likely to be disabled, right? But I think, as Lyria said in her response, it would also, we worry though, because it could be seen more as a post hoc rationalization than as an account of the reasoning process that led to the actual determination. Now, of course, maybe there was no reasoning, right? Maybe it is just a pure correlation machine, in some way, but it seems as though in any given potential set of correlations, there would be many possible correlations. And therefore, to give some rationale for why this one and not others would be important. So I guess that would be one way of thinking about it. But I'm just thinking about, out of millions of claims, having, it's no person, I think, could think about a million claims at once and think about in which situations did people with 4 diseases, those certain 4 diseases always get disability and others did not. But the machine could recognize that. Maybe it's as simple as that. Maybe it's as simple as like, well, these were, it turns out that everybody with these 4 diseases got disability and nobody with those 4 diseases did not get disability, right? But I mean, I think that sort of is the type of thing where I'm assuming, and I think we're assuming that like in the future, it's going to be more and more tempting to do this either as triage or as a selection mechanism. And I know that, in earlier work, I've critiqued Nicholas Eletris's and co-authors' work on predicting the European Court of Human Rights. But this is where I think that's what we're trying to anticipate, is that possible future. And I can get into the more jurisprudential side as well, which we didn't get into earlier, but that would be my response.
This great discussion. I think that if we produce generative AI-driven explanations, actually, also going back to the comments from Lyria, and the general question here, for dignitary reasons, of course, is not helpful because you just have someone that has a result-based solution. For an internal accuracy check and a fairness check is not helpful because it's just a post-hoc. But for enabling rights, I was now thinking to try to develop this cyberpunk scenario where all explanations happen through generative AI. I think it really depends on the administrative due process, depending on the state. If that state has a more formalistic approach to administrative due process or a more substantive. But what if the generative AI-driven explanation is binding for the control on the decision? So just making the example, the public administration doesn't give me a benefit, and gives me an explanation driven by ChatGPT, then I want to challenge that decision. The court some courts in some systems might criticize the appropriateness of the decision based on the wrong reasoning. So is the ChatGPT reasoning, if the ChatGPT reasoning is maybe wrong, but the decision might have been good because it respected the administrative state, but the decision was built on wrong basis, the court could say the decision is wrong. And this could be a damage for public administration because formally, because substantively the decision was correct, but the explanation that was given to me was developing wrong points, and so I won the case. So this, I was thinking on like stretching this, and maybe just an analogy with what is not public administration, because in what if we receive, and this is maybe the risk, insurance, banks will receive a no. We have a right to explanation maybe according to the GDPR, but we don't, and the right to contest, but we don't have a right for a new, better decision. We have a right for a human implemented decision, but we don't have a right that contestation is really taken into account. And they might give us this fake generated explanation, and it would be the end of the story. So, and they are not problematic under the AI. They are not considered high risk. So just to say, I'm also scared of the private discussion.
I really have, I'm really on the edge of my seat. To one thing I want to respond to is, I think you're sort of scaremongering with respect to generative AI. And I was reminded of a thing that Mireille said this morning. I don't care about what's inside the head or inside the model, as long as the justification is there and respects the law and is contestable and so on, right? And in that sense, I don't think it's even possible for a legal decision, a subjective decision like you are eligible to get benefits, because there's no kind of ground truth or something, right? So these people should, well, there is sort of, but there's a big gray area in between, which depends on the judges that made previous decisions, I guess, and the way judges decide. You might not be able to get disability benefits 100 years ago if you are diagnosed with autism. Now you might be, right? So the decision cannot be right if the justification is wrong, is what I'm trying to say. Right? It's we get the right decision but the wrong justification. I'm like, that's impossible, because the justification is the decision in a sense, right?
But jurisprudence works in certain times in ways that are not purely black or white, but they're just formalistic. Like you say, the justification was wrong, and the judge might say, so the case was. But
then again, why should we expect? Why do we want to look inside of the model? Well, we also kind of look inside of the head of the judge, right? Or whoever's kind of the civil servant who's determining this. Why do we?
Yeah, it depends on the procedural law. I'm just saying that in some systems there might be the case.
But I think from a computational perspective, if you don't really have the explanation and your justification, if it's next word guessing system, then you also don't know if the decision was right or wrong. So there is this.
I think you should use a microphone for Frank.
Oh, I could hear. Yeah.
Okay, so this is the famous trade-off between accuracy and explanations. But I think that's a fake opposition. If you don't have an explanation of why the system came to that conclusion, you cannot say that it was accurate unless in a very narrow way. So I have two points. I think in private law, the fact that you would not have a right to a new decision, that depends. There is consumer law, there is protection for housing, for insurance law, there's non-discrimination law. So it's not the case that in private law, a company can decide whatever they want. So the contract, the freedom of contract, Article 16 of the Charter, the freedom to conduct a business, has a comma. And after that comma comes something, and that's important. So some people think public administration has to give reasons, but people in private law can do whatever they want. That's, of course, 19th century bollocks. Let me see, what did I write down? I actually have no idea. Yeah, so then one last point on the first presentations on multidisciplinarity, interdisciplinarity, transdisciplinarity, and cross-disciplinarity. I missed in the discussion the idea of epistemic trespassing. And it's interesting that the example of criminology was given. I hope there are no criminologists here, please leave the room. Because I'm always very disappointed. I've worked a lot with criminologists in a research school in the Netherlands where lawyers and criminologists collaborated together. And I'm sorry, but I often found that they know nothing. They have some general idea of a lot of things. Usually they hate statistics, but thank God they have SSRP or whatever it's called for that. They don't know how software works. They have no idea what the software actually does. They just blindly trust it. And they're also always doing data dredging, etc. So they're picking up a theory, massaging the data. I'm sorry, but also under the supervision of their supervisor, this happens. So I've been very shocked very often about what happens within criminology. So I would argue for no, monodisciplinary is not easier at all. It's much easier to take small sips of a lot of domains and then to fly through them, then to say, okay, we're going to make sure that we really know about the law, that we really know about computer science. So there are people who do both, that exists. You can't expect everybody to do that. So I think the idea of 5% or whatever percentage of people who have both, and maybe there are people who have 4 degrees, it does happen. But this idea that we should have a sort of a mix of all sorts of, I think it's a very bad idea. And it's like institutionalizing epistemic trespassing, to say something provocative. And I'm very serious.
Yeah, I have a question for Lyria. So if I understood correctly, first there's a clarification, but if I understood correctly, you sort of introduced the idea that maybe we shouldn't focus on certain elements that we tick, like human intervention or anything, to see if the object of regulation is present and if the regulation should apply. But that we maybe should look at certain contexts. So for example, government is making a decision. Is that correct?
Yep.
Okay, so if that's correct, then my question is the following. And I'm sorry that I've apparently taken the role upon me to be the person that says a lot about Dutch law today. But if I look, for example, at Dutch law and Dutch public law, then one of the criteria upon which a lot of detailed rules apply and on which you can actually go to the administrative judge. So I recognize that it's very much a civil law and not a common law thing. But if you look at this, then the presence of a public law act, so something that is based on a discretion or an ability that's based in public law and that has legal effect. Yeah, it's very detailed, I'm sorry. That determines whether there are very detailed rules and whether you can go to an administrative judge. And for all the other things, you have to go to, it's not that there's no law that applies, but you have to go to a civil judge, and there's less protection in the sense that the judge helps you if you're a citizen against the government. And then my question is, if we would, for example, look at the government context, then can we ever avoid seeing if certain boxes are ticked? Because, for example, here we're sort of looking at whether it's in a government context, but because we have made certain decisions on what we think administrative judges that have a very different role should do and what civil law judges should do, we still have these boxes to tick. And at least I think if I rationalize from the Dutch legal system, then, for example, data collection is not supposed to be something that, as a citizen, you can oppose. I mean, maybe under the realm of a final decision, but not in itself necessarily.
So by saying context, and I used the government decision as an example of context, I didn't mean to say that is the only context that would trigger something. And Mireille, you've already mentioned, even if you're in the private law side, then there are certain contexts where particular, so to give an example, consider something like discrimination law, which I think needs to be rewritten, but that's another debate for another day. But the idea is, if I say, argue that someone has treated me differently because whatever, and that is then a dispute, then the reason for the decision, whatever it is, a hiring decision, whatever, becomes contestable. And if the reason is whether it is I used a tool and the tool has the problem, or whether it is a human who had some was sexist or whatever it was, then either way that the reasons for the decision become contestable, and they have to sort of demonstrate, no, we didn't hire you because you're hopeless and you come up with crazy ideas about stupid degrees, and that was the reason for the decision and not the one you said. So so that would be another context in which, the sort of explainability would be contested. I'm not going to even try to speak about Dutch public law and the different dimensions there. My point is more that if you build it up from that, and you sort of say, well, what are the expectations based on context, rather than, was it a foundation model? Is it AI under a definition? Is it a solely automated decision? And you build your reasons for particular things being required on those kinds of logics. I think ultimately you end up in a more stable place, because one of the things, the argument about foundation models is an example of that, is that there'll always be new things, and they have to say, is it in, is it out? People, in other words, it's a constantly changing space. Whereas contexts like, unfortunately, discrimination and government decision-making and consumer law, they are much more stable.
Do you want to respond to Mireille as well? Provocative comment as well.
Is my idea a terrible one? I haven't actually decided if it's a good one or not. So you called this originally a provocation paper, so I felt I had to be provocative. I think it could be a terrible idea, and I'm completely open to it being a terrible idea. The point, I suppose, is why we think the boundaries that are already there are the right ones. So I can't remember who said it. One of you talked about method, was that? Yeah. As being, but in fact, that isn't the basis for the legal discipline, right? We actually use a lot of methods. I mean, doctrinal method is potentially unique to the legal discipline in the sense that, as far as I know, no one else uses that. But legal scholars, the percentage that are purely doctrinal legal scholars is actually relatively low, at least in Australia. So it's not that we're unique because of method necessarily. It is where lines have been drawn over a long historical process, right? So maybe going back in time, everyone was a doctrinalist in law, and then over time we've introduced socio-legal and other things have come in, and people would still say that they're part of the discipline of law, but they're using different methods and they're thinking in slightly different ways, or they're legal philosophers and so forth. So we've drawn lines in particular places, and there might be some lines that are really bad. I'm not a sufficient expert in criminology to know whether that's a good line or a bad line. It could be terrible, it could be wonderful. But I guess my question is, can we question those lines based on change, right? So if we're seeing now that there are fields of endeavour, cybersecurity, I think was a sort of easier example in my mind. There are huge numbers of people now looking to do this, and it's a really important role to play. And it seems to me that you can't do it from one discipline alone. And we have way too many people coming through who think, I've done computer science, I can do security. And I don't believe that's true either. So it might be 5%. I'm not suggesting that we get rid of disciplinary programs. I'm just asking, I suppose, are there different ways of drawing lines? Could we imagine, I mean, people are now doing computer science law dual degrees. Those people get a full computer science degree and a full law degree, and the two never speak to each other. So at an extreme level, and without taking away anything from that, could we imagine replacing it with a longer program, which is the same length as a computer science law dual, but that allows those things to be brought together? So there's no dilettantism in that context. They're still doing the full law degree, they're still doing the full computer science degree, but because we've created it as a program, potentially there can at least be courses inside that program where they are doing and focusing on the intersection.
Yeah, you're also talking about engagement, putting people in the same classroom so that...
That was option number 2, yes.
Yeah. So I have been appointed at the computer science department where I've been teaching, most people know this narrative, law to master students of computer science. And they are my best law students, I'm sorry to say so. I don't know how come, but I always had to tell them, guys, you are 5 steps ahead of me in the wrong direction. So you're now 10 steps behind, so get on to it. But I got my 13 weeks, so that's a full semester, master course, the master students of computer science. Sorry, they're very bright, they're very open, they very much understand that law is not a bag of rules, because any computer scientist knows that if you change something here in the system, it's going to change here, there. They understand that much better than lawyers, to be honest, law students. So for me, that worked. I got papers at the end of the 13 weeks that I had not yet received in law students, in law school. So I'm not against cross-disciplinary engagement. I'm just worried if you say, okay, let's do 4 years, do a bit of law, some philosophy, a bit of criminology, which is all that, etc. That's what I would be worried about. We have an AI program at the computer science faculty. We also have an AI program at the psychology faculty. And let's say I hear some talk about what they think of each other, and then I get a bit worried. So people who say, oh, I know all about AI, and the computer scientists say, well, yeah, that's what they think. And that's sometimes very problematic. So, yes.
I want to add a sort of, it's a little far afield from the general topic, but there's really a question, at least in the United States, of whether law is an academic discipline. So law is defined for the United States. Law is, what do you do at law school? You learn to be a lawyer. And we have academic schools, and then we have professional schools. And the professional schools are the medical school, the law school, and the business school. So when someone graduates from law school, what have they learned? Okay, let's not, please, I don't want to hear I teach in a law school, I can't handle the pain. They've learned something, but maybe they haven't learned an academic discipline. And I know that in other places, you're a law professor, you've gotten a PhD in law. That's not true in the United States. And there's a lot of people running around who are US law professors who have no really advanced training. They've been to this professional school. And so there's really a question in the United States of whether law is an academic discipline at all. And so what you see, there's another wrinkle, which is US law reviews. I'm too ashamed to discuss that, so we can't talk about that right now. But what you see is a lot of law professors in the United States casting around for a methodology that they can use to study a subject. And it's so you end up with a really wide range of types of methodology, not necessarily because people think this is intrinsically a hybrid question, but because we have no training in methodology. And so sometimes you'll have I had this conversation with a law professor who was a little bit older, and I said, what is the methodology that you use to study? He said, I have no methodology. I said, what are you doing? And he said, I'm studying the right meaning of the law. And I was like, I'm gonna get some more some more food, but thank you. It's been good to speak with you. You know, so like this is not a deep self-reflection. Is this a discipline? Is it people casting around for other disciplines? I think this is actually a hard question, at least in the United States, where we have pretty limited training. And what we see in the United States is increasing, not strictly true, increasing on the longer scale, up and down year to year, of entry-level new law professors who actually have a PhD in another discipline, who are coming with a methodology that they have fully trained in because they have not learned that methodology in their 3 years of law school. So that's kind of just another wrinkle to the conversation. There's a question back there.
I wonder where I can add some conceptual framework to a lot that has been said, and that actually in part goes back to the paper Frank referred to, the paper I wrote in 2018, 2019. And I think that framework that I had in mind when I wrote that paper might extend to the discussion about explainability with ChatGPT, and that is the following. In that paper, I analyzed the outcome of predictions with case law. That was the limitation of that paper, which was banned in a hot topic where you had Nicolas Aletras and some others studying, can we actually predict a court? Daniel Katz is doing the same without any aspect of law. He's just, with the metadata, predicting what a court might decide. So I had been thinking then at that moment, analytically thinking, what can I do with such outcome as a judge? Is it a fact? No, it's not. Is it law? Is it precedent? Is it a statute? No, it's not. And then I also came up, is it evidence? And last year, Frank already questioned. I said, no, it's not evidence. And Frank questioned that. So I went back to my reasoning, because if Frank says it might be evidence, then I really have to think, well, is it evidence, is it not? It's a very valuable comment and question you made there. So what I've learned is that under American law and under English and Welsh law, evidence is defined in a much more broad way than it actually is in civil law countries, than it is in Belgium, France, and the Netherlands. So that's one point. But then, why in the final thesis of my doctorate, I kept my analysis is, and that's the framework I would like to add today to the discussion. Statutes and precedents are made on a general level, and they set conditions within which law is applied. The court case is on the concrete, specific, even individual level. As a judge, you decide, administrative judge, but civil law, commercial law, criminal law, it is between party A and B. It's about this specific misdemeanor criminal fact. And then you have that whole treatment of legal facts of law with a probabilistic outcome, with it's a level of possibilities and of probabilities. So that level of probabilities, what does that actually say something for me in the individual instance? And that is a different level of abstraction, I think. So if you start using ChatGPT to explain what the decision might be, you again involve that probabilistic, that level of potentialities into a specific concrete case. So how can you make that jump? And under what conditions can you make that jump? Is partly, I think, the methodology of computer science and of the modeling and of the data selection, but also is a societal decision to be made. And to be said, well, in these circumstances, we accept the outcome for the individual case. So I just wanted to submit what you think about that. And then maybe for the second thing, what Mireille said, that she has seen excellent papers from computer scientists about the law and how computer scientists understand. I think it's a matter of training, indeed, what you have said as well. It's a matter of structured thinking and about, thorough methodology and thinking things through in an appropriate way. But that's the first thing was the more important.
Just one remark on that. So I think me teaching law to computer scientists, in that process, of course, I made explicit the methodology of law. Yes, of course, law has a methodology. I'm always flabbergasted that people say it doesn't. No, it does not have the methodology of the natural sciences or of medical science. Also not of social science. It's closer to the humanities, but it's a professional, it's a practice that influences the theory, and the theory impacts directly the practice, so it's a very special case in a different way from medical science. But this conundrum that we don't have a methodology, that damages the academic status, but also the protection that law offers. We had a Dutch scholar who wrote in a newspaper that a friend of him, who was a natural scientist, said, "What method do you have?" And he said, "Oh, we don't have a method." And that article unleashed a terrible downgrading of the law. Oh, these people, they don't know what they're doing. They're just doing something. They're all biased and prejudiced. We should, as lawyers, insofar as we are lawyers here, we should resist that. Yes, there is a methodology, and we have to help computer scientists and others to understand that methodology. And it has a normative backbone. It's not some sort of neutral, objective stuff, which does not mean that it's arbitrary. It's the contrary. It's about countervailing powers, etc. Sorry, but you had a very clear question.
Could I jump in? Well, I just wanted to respond to Geneviève's comments, which I thought was very illuminating, and also the point, Ray, your response, just to affirm your response on methodology. I'll start with that, just methodological point. I do think that, what's fascinating is I think that in a lot of legal scholarship, at least US legal scholarship, there's a lot that is worse than scholarship that is more algorithmically, methodologically determined, and there's a lot that's better. I think that certainly, there's a lot that is, there are many very wise critiques from within law of blind spots in economics, philosophy, political science, other disciplines. And so I would not want to see a legal academy that was entirely dominated by those with PhDs from outside of it, because I think that would, we'd lose the sort of leverage on critiquing blind spots, which I think is a characteristic of a lot of very good legal scholarship. I think that with respect to the Genevieve's comment, I think that, you've really helped illuminate something for me about a larger trajectory of work that I'm trying to develop now, which is I would classify as diversifying modes of judgment, which is to say that, and this I think really gets also to some of the distinctions between interdisciplinary versus transdisciplinary ways of thinking about the intersection of computation and law, because I think that part of where Gianclaudio in my paper is going is saying that in certain neediest cases, we could even set aside law and all legal requirements and simply do computation and say the computer tells us that these 2% of cases are the neediest cases, right? And I'm not saying, and I know that may sound scandalous to some, but I think that sort of, I would, in a way, say, let's just give it to computation, let them figure out what they think are the most important factors to extrapolate from past cases toward the present. And for that 2% of neediest, because it's not denying anyone a benefit, it's just giving people's benefits, that 2% could be done entirely computationally. I think there's also a case for setting up within largely computerized processes an alternative where, say, 5%, 10% of people, if they're rejected by the algorithmic system, get to put their case in a narrative way to some person, right? And so what ultimately, with my viewpoint, we could diversify by saying there's going to be some things that are pure computerization without law. There's some things that are going to be purely narrative with no computerization. And there's going to be this broad middle range where we're going to be trying to integrate as best we can the best of computer science and the best of law, or the best of computational method and law. So that sort of is my way of responding. I know it doesn't do justice to your intervention, Genevieve, and I want to come back to it eventually, and maybe we can talk about offline at some point. But I would really, that's sort of where I think it would be going in terms of trying to think, maybe to circumvent this question of where does the computation end up as evidence from either a common law or civil law perspective. So thanks.
Can I ask you, when you say that it's not law, so I'm not sure I understand that. So what if the law says that people who have condition X are the only people who can get benefits? And the person writes into the code that people who have condition X should get benefits, but in fact, though Congress didn't pass this, you can see that actually somebody without condition X who makes no money a year is a person more in need. If the code says to give that person benefits, surely that violates the law. We can't say that there's no law, there's only computation. The computation is, in some sense, enacting the law. The law is not absent from the computation.
Sure. No. I totally agree with you on that particular hypothetical. I was thinking, and I should have made my assumptions clearer here about the background, is I was thinking about things like what Eletris did. The Eletris had this sort of a very complicated bag of words approach toward sort of predicting which cases would be found rights violations by the European Court of Human Rights. And I was thinking that something similar might come out of, say, the million Social Security cases, where we might just have a very large scale analysis of those cases that would assign certain words in filings as being particularly indicative of disability, and with no real connection to whatever the law of Social Security was, but it's just if those words are there, and I'm guessing there will often be names of diseases, would just say those people automatically get the claim. But yeah.
I don't understand that hypothetical, because presumably the law of Social Security is something like, if you are it's something broader, right? If you are unable to work, then, if you're unable to work in the economy because of disability, then you get benefits. And then the program that you're proposing, you're saying would be trying to make specific that general law, but it's not detached from the law. We would not write a program that says just go out and figure out the best way you can of who is in need against what the law states. Here's a person with no disability. So I'm having a very hard time. It's not detached from the law. It's enacting the law. It's what happens in Social Security determinations all the time. I'm still missing, I think, what you're saying.
Well, I think to give another example from the Eletris piece that sort of is inspiring this in a way. In Eletris, they said, here are certain words that would be broadly pointing in the direction of, or pushing, or vectors pushing in, say, a support vector machine model, something like that, vectors pushing toward a finding of rights violation. And they included words like copy, individual, things like words that really, where you're like, I don't see how that word connects to the law, right? And so this is what I'm saying. I'm saying that, to the extent we can recognize what's going on, yes, we're going to have to recognize it via things that have some passing resemblance to what are the legal categories that are involved. But it seems as though for it to really take on the shape, the full shape of the machine learning capacity would be beyond what we could explain. It would be sort of just saying, this is a group of words that seem to indicate successful claims in the past without reasoning about what those words entail. That's all that I'm trying to push forward as the emergency, the positive emergency application of computation, absent the application of legal standards in the particular case.
Hasn't that paper been called out as suffering tremendously from
data leakage? I think they have closed the mic now. So that paper suffers tremendously from data leakage. So the predictions that are in it are, let's not say false, but overblown. So they're not 77%, but 54%, so you can also toss a coin, which is much cheaper.
Well, I have so one. I think this is interesting that kind of that you say, Frank. You say in positive instances we can use, so not recidivism prediction or any other kind of negative consequence, positive consequence. We can just predict, but maybe I'm too cynical here. For any positive decision you make, you lose so. I'm not the so many percent that gets automatic benefits, right? Then I appeal to that and I said, well, you didn't use the right words, or we don't know. I mean, so isn't the problem just the same? I mean, it sounds like it's nice, just give people who the algorithm thinks, give them their benefits, but that also means you're giving a lot of people not their benefits, and they might have good reasons, right?
Yes, and I guess this comes from the U.S. perspective of being a sovereign currency issue that can just print the money. So no, I'm just kidding. No, I don't mean that. What I will say is that it could come though from, if we assume a fixed pot, which weirdly enough though in the U.S. it's not a fixed pot. It actually more and more will be drawn from general revenues, and so it is actually the case that it's not a fixed pot. But if we assume a fixed pot, then you could say out of that fixed pot, 2% go in the completely automated category, 5% go into the completely narrative category without any touch of on automation. You could do that. You know, that would just be the nature of my prediction. And so you're right to say that, like, yes, there are people that might say in the broad middle, wow, I would have been at the edge and I should have gotten it. So I could see that. But I mean, but I think that it is, it really depends on your baseline. And so, yeah, but your baseline point is well taken, and in a full elaboration of the proposal would have to be dealt with. Yeah.
Well, we could definitely keep going, but I think we have run out of time. So thank you to the panelists and to those who participated.